Hello, my name is Nina Parker. I am a consumer bankruptcy lawyer and have practiced in this area for over 30 years. My office is in Winchester, Massachusetts, and so my experience in practicing law is in Massachusetts. Our firm, Parker & Associates, represents individuals in Chapter 7, Chapter 13s, and Chapter 11 proceedings, as well as regular workout opportunities. In addition, we represent small businesses in Chapter 11s or other types of workouts. Today, I have been asked to provide an overview of Chapter 7 bankruptcy. The information which we are going to go over is intended only as an introduction to bankruptcy, and I want to be sure that as you participate in this program that you recognize that no legal advice is being given and that this is just an introduction to bankruptcy. If you are an individual or a business owner seeking assistance with bankruptcy, you should absolutely consult bankruptcy counsel. And if you are looking for counsel, I urge you to seek a well-qualified attorney because it is very complicated and there's so much at stake. I'm a board-certified consumer bankruptcy attorney. I'm also a member of the American Bankruptcy Institute, where I am the chair of the Consumer Committee. I'm a member of the National Association of Consumer Bankruptcy Attorneys. These are all organizations which you should look to if you are looking for assistance. If you are an attorney and considering getting involved in the practice of bankruptcy, then I cannot urge you enough to join these organizations. Take advantage of their legal education, their listservs, their mentoring, and their conferences. Taking on the representation of an individual should not be done lightly because there's so much at stake. I'm really glad that you've decided to join with me today to go over the basics of a Chapter 7. And so with that, let's get started. As you can see from the slide, we're going to review today how to determine whether or not bankruptcy is an option, as in some instances there may be reasons for a client not to file bankruptcy. The types of bankruptcy that you are likely to recognize as something that would be beneficial to your client are one of the options that we're going to discuss today. We are going to review how to determine whether or not bankruptcy is an option for a client. What are the types of bankruptcy? What is the automatic stay? What is a discharge? And what is PACER and CMECF? Perhaps you've heard those terms before. Our presentation today will be a number of things. First of all, a bit of a bankruptcy timeline. Then, at the very end, I'll provide you with a list of resources and some websites, but they're not exhaustive because I practice in Massachusetts, but you may be watching this from anywhere across the country. So check your local listing for sure. And finally, we're going to give an overview of a preparation for the schedules for a Chapter 7. So, types of bankruptcy relief. Who is eligible? For a Chapter 7, individuals and businesses are eligible. For a Chapter 13, which is called a wage earner plan, individuals or sole proprietors are eligible. But there is a debt ceiling. The debt ceiling, as of right now, April 2012, for unsecured debt is $360,475, or for secured debt, $1,081,400. Those are odd numbers, and they do change every April, so be sure to check each year if you're watching. Chapter 11s, both individuals and businesses are eligible. There is no debt ceiling. Before you get started on representing somebody in any type of a filing, it's important to have a checklist, documents for things to consider. The homestead is the #1 consideration, as many people file a Chapter 13 or Chapter 7 in order to obtain a fresh start or to save their home. Homestead protections are available either by state statute or through federal exemption law, and you will need to check that. Credit counseling. In 2005, the bankruptcy laws changed, the Bankruptcy Abuse Prevention and Consumer Protection Act, and every individual who files a chapter proceeding must take credit counseling. There are approved agencies, and you can find that list on the Department of Justice, United States Trustee website. Has the person filed their tax returns? It is important to determine whether or not they have. Filing of tax returns is not a requirement in order to file a bankruptcy proceeding, but it's very important that you have received at least the last tax return filed by the individual. Payment advices. That was another change that went into effect in 2005 when BAP-CIPA went into effect. A debtor must turn over the last 60 days of payment advices to a Chapter 7 trustee, and you must collect the last 6 months of pay stubs in order to conduct the means test. Finally, Deciding whether or not to put an individual into a Chapter 7 will require that you undertake some estate planning considerations, because many times a debtor has been the recipient of a transfer or has transferred property, and that could impact their ability to obtain a fresh start or to retain their home or homestead protections. Now, what is the main reason why somebody would file a Chapter 7 proceeding, or actually a Chapter anything proceeding? And that is called the automatic stay. The automatic stay is a fundamental protection of bankruptcy. Section 362 of the United States Bankruptcy Code, 11 U.S.C. Section 362. It protects the debtor and it protects the property of the bankruptcy estate. The scope and the extent of a protection of the automatic stay depends on the type of the debtor and depends if there has been a prior case. So it's very important also that when you do the intake with your client, that you determine whether or not this is their first bankruptcy proceeding. What is relief from the automatic stay? The automatic stay goes into effect the second that somebody files a bankruptcy proceeding. It's filed electronically. But relief from the automatic stay can be obtained by a creditor for cause, for lack of adequate protection. And those are things which are beyond the scope of today's conversation, but you will want to know more about them. You should know that there are sanctions for willful violations of the automatic stay, and there are actions that can be taken to protect debtors if that occurs. When the automatic stay goes into effect, what is stayed? Examples. A foreclosure action is stayed. Collection actions are stayed, including collections for medical bills, credit cards, but not for police actions or for parking tickets. Yes, for wage garnishments, but not for restitution or child support. There can be the automatic stay that can go into effect that can assist co-obligors for debts, but that really has to do in a Chapter 13. So don't depend on a Chapter 7 for the co-debtor stay. With respect to divorce, that is another topic which is broad. We can only touch on that today, but I can tell you that in the event of a divorce proceeding, the division of property is stayed, but there is no automatic stay that has to do with respect to alimony or child support. So let's move on to the next slide. What is the other reason that somebody would file a Chapter 7 proceeding? They want the bankruptcy discharge. We're going to review who gets a discharge, what is a discharge, what debts are discharged, and are there debts which are accepted from that action. For example, certain taxes may not be dischargeable. Student loans are not dischargeable, and domestic support obligations are not dischargeable. A discharge is intended to provide an individual with a fresh start and allow them to walk free from a bankruptcy proceeding with retained assets only which are able to be claimed as exempt. Who gets a discharge really depends on the situation, but only individuals are entitled to discharge. Businesses do not get a discharge. And there are instances where a discharge can be denied. That is also a subject for another day. In 2005, as I indicated, they changed the law, and there are certain changes that had to do with discharge. In a Chapter 7, you may not obtain a discharge again until 8 years has elapsed between filing dates from one Chapter 7 to another. In a Chapter 13, there are 4 years between the filing date and the filing of the Chapter 13 proceeding again. A filing and a filing again, sometimes known as a Chapter 20, which is a Chapter 7, and then a Chapter 13, is often used when people are seeking to discharge obligations and then working to resolve undersecured mortgages. There's a big split of authority right now with respect to whether or not Chapter 20s are an available resource for individuals seeking to do that, and I urge you to stay tuned for that. As I indicated in the outset of this, there are certain resources which are available to you. The American Bankruptcy Institute, which as I spoke about earlier, is a very wonderful organization providing not only continuing legal education, listserv, and other types of avenues for obtaining additional information, as well as resources for finding other counsel, the National Association of Consumer Bankruptcy Attorneys, the National Consumer Law Center, and of course, each of your United States Bankruptcy Court websites. We're now going to move on, we're going to take a short break, and we're going to move on to the Chapter 7 schedules. Welcome back. We are now going to review the preparation of a voluntary petition and Chapter 7 schedules. We are not going to review Statement of Financial Affairs, nor are we going to go over the means test today. That will be for another day. We are going to review the disclosures that are mandatory since BAPSIPA went into effect, including the credit counseling and financial management certificates, the B1 official forms, and Schedule A through J. So, notices. When they changed the law in 2005, they made it mandatory that each individual be given a notice called a 527A2 notice. What that is an introductory communication with a debt relief agency notation that is clearly visible. As debtors' attorneys, we are debt relief agents. What it tells to an individual is that information to be provided to them must be truthful and accurate and must be fully completed. That all assets and liabilities must be accurately disclosed, and it explains about current monthly income and expenses, and also talks about the fact that an individual may be audited. I provide a notice to my individuals, which they sign, and you should do one as well. And what it does is it shows a place for them to have the disclosure for their signature and for your signature as well. The second notice that is required to be given is called a 342B1 notice. That is a notice that is provided by the court. It briefly describes Chapter 7, Chapter 11, Chapter 12, and Chapter 13, but first it describes that you may want to choose another option and not file a bankruptcy at all. An individual will be provided this at the time they sign the bankruptcy petition, but you should consider giving it to your individual when you meet with them at the first meeting. And have them sign it, because what it does is it means that you've explained to them that there are services that are available from credit counseling agencies and that there are 4 types of chapters out there. It also tells them that it is a crime not to disclose any of their assets and liabilities and that they should consider this action very carefully. There's one more notice that is required to be given to an individual. I like to give it at the first meeting, but some individuals receive them by mail from their attorney following initial consultation, and I understand that some people mail them out, in fact, before their first meeting or send them by an email. The notice is given at the same time as the 342B1 notice, and there is a signature line for them to say that they received it. This is an important notice because it tells an individual that they have the right to prepare a bankruptcy on their own to use an attorney or a bankruptcy petition preparer. But the law requires that an attorney or a bankruptcy petition preparer give a written contract specifying what the attorney or bankruptcy petition preparer will do for them and how much it will cost. It also gives information that is written in a way that an individual can understand, but it explains to an individual that before filing of a bankruptcy case, that your facts should be analyzed carefully to determine what type of a bankruptcy proceeding is the most beneficial for you. If you are representing an individual who is going to file a Chapter 7 proceeding, they may be asked to reaffirm a debt, such as a car loan. You should counsel them very wisely before having them sign one, because it is essentially bringing that debt back, and they will not be able to discharge that debt in their bankruptcy. Reaffirmation agreements are sent by the creditor to the debtor and need to be signed and filed with the court before the discharge is entered, or will not be effective. You should look into that more carefully. As noted in the 527B, you must always have a fee agreement with your client. I give my clients an engagement letter, a sample, at the initial meeting so that they have time to read it before they come back the next time with a signed engagement letter and we proceed. Filing of a Chapter 7 is only the first step, and there are certain things that have to be done in order to avoid a dismissal of a case on its face. One, as we noted before, is they must obtain a credit counseling certificate. Credit counseling must be taken before the Chapter 7 petition is filed. Actually, it must be taken before any bankruptcy is filed and can only be taken by approved credit counselors, as noted on the United States Department of Justice website. If there is an emergency and you are not able to assist your client in obtaining their own credit counseling before the filing, and an emergency filing takes place, there is a situation called a motion for extension of time to complete consumer credit counseling under Section 109H. It must describe in the certification that there were exigent circumstances. It must be signed by the debtor. The exigent circumstances must merit a waiver, but you can only do that if the debtor has sought and been unable to obtain credit counseling within 5 days of the filing of the bankruptcy petition. Now, I recently had a situation where a gentleman called me, and it was the day of the foreclosure. In fact, it was hours before the foreclosure, and he needed to do a filing. He drove to the courthouse, he filed his bankruptcy petition, and he took his credit counseling, but the certificate did not issue until after the case had been filed. And as a result, the court issued a motion to show cause, and in fact, the case was dismissed because he had not tried to take the credit counseling within the 5 days before the filing. In a situation like that, the case will be dismissed, but typically dismissed without prejudice. The debtor can then take the credit counseling and file a new motion, can file a petition again. But it must be accompanied by a motion, because when there is a second filing, a special motion must be filed, and it must be heard within 30 days in order to maintain and continue the automatic stay. Credit counseling is a very important certificate to have. I like to have it in my possession at least 24 hours before a filing, and you should too. At the end of a case, there is the financial management certificate. Also must be given by a course which is given by an agency approved by the Department of Justice, United States Trustees. The debtor must obtain that certificate of completion of the personal financial management course as described in Section 111 of the Code, 111 of the Code. In the event that a debtor does not obtain the financial management certificate, the case may close, but the debtor will not obtain his discharge. That is a dramatic result, because here they've gone to all the effort to file a Chapter 7 to obtain a fresh start, and will end up with a case closing without one. In fact, you can reopen the case in order to take and file the personal management certification, but it's an extra cost, and it's a lot of anguish for a debtor whose case does not have a discharge. So all of these things, as I've indicated, are steps at which you need to be aware of in order to avoid the dismissal of a Chapter 7 proceeding after you've filed it for your client. The way the code says is that the failure to file all information under 521A1, the case shall be automatically dismissed effective on the 46th day of the filing of the petition. So if you don't have all the information necessary to file, go ahead and file an extension, because you can ask for an additional 45-day period. If that's not sufficient, then you must be prepared to go to the court with a motion and affidavit signed by the debtor, and must be able to prove that the debtor attempted in good faith to complete all the documentation requirements, and that it is in the best interest of creditors and the service of the administration of the case that the case not be dismissed. Those are all the really hard things we have to talk about in terms of getting ready for a Chapter 7 filing. What you have now is you've gotten your client in, you've given them all the certifications, they've taken the proper course, and they're ready to file their bankruptcy petition. Just what is a bankruptcy petition, and what does it look like? The bankruptcy petition is an official form, B1. The form was last changed on December of 2011, but they are updated often, so you need to be sure and check with that. You should definitely use software. What goes on to a bankruptcy petition? The name of the debtor and a joint debtor. If it's an individual, you're going to enter the first name, the last name, the middle name, and all other names used by that individual in the last 8 years. You need to include their married names, maiden names, trade names, DBA, any name which they might be known. The second thing is to provide the last 4 digits of the Social Security number or the individual's tax ID number. This is done for security purposes because it is a public document, but because of privacy, only the last 4 digits of the Social Security number will appear on the face of the bankruptcy petition. There is a line item for the street address of the debtor. You'll need to give the number and the street, the city, and the state, the county of residence, and if the mailing address is different, you need to check that off as well. It is important to note that the debtor on the petition is an individual and whether or not it includes a joint debtor or not. The petition also provides a space for checkoff as to whether or not the filing fee is attached or whether or not the filing fee is to be paid in installments. If you are representing indigent debtors or individuals who do not have sufficient funds in order to pay the filing fee, there is a provision to file a motion to pay it in installments or to obtain a waiver. Of course, if the full filing fee is attached, you need to note that as well. The final thing on the cover of the bankruptcy petition is to check off what chapter. In this case, you'll note that all chapters filed the exact same petition, but the checkoff box is what's required to tell the court this is a Chapter 7 proceeding. On page 2 of the voluntary petition is a place where it can be noted where all prior bankruptcies have been filed within the last 8 years. You must note the location where the bankruptcy was filed, the case number, and the date that it was filed. You should also note that if there is a pending bankruptcy by either a spouse, a partner, or affiliate, that information must be provided as well. Just below that is what's called Exhibit B. Exhibit B must be completed by an individual debtor whose debts are primarily consumer. As the attorney, you must certify that you have informed the debtor that they had the opportunity to proceed under a Chapter 7, a Chapter 13, or a Chapter 11. The next part that we're going to look at on the second page of the petition is the Exhibit C. Does the debtor own or have possession of any property that poses or is alleged to pose a threat of imminent and identifiable harm to public health or safety? If yes, then you must attach a separate page and explain. If no, move on. Exhibit D. Exhibit D must be completed by every individual. If there is a joint petition that is filed, each spouse must complete and attach the separate Exhibit D, and you must note that there. Exhibit D has to do with credit counseling certification. The last portion of page 2 of the voluntary petition is the certification by a debtor who resides as a tenant of residential property. There is a checkoff box if a landlord has a judgment against the debtor for possession of the debtor's residence. If the debtor claims that under applicable bankruptcy or non-bankruptcy law, I should say, that there are circumstances under which the debtor would be permitted to cure the entire monetary default that gave rise to the judgment for possession after the judgment for possession was entered, and that the debtor has included in this petition a deposit for the court, with the court, of any rent that would become due during the 30-day period after filing of the petition, then a certification must be filed and you must give notice to the landlord the certification. That is 11 U.S.C. Section 362L. We are still on the voluntary petition. We're going to move on to the next page. Signatures of the debtor, both individual and joint, and signatures of counsel. I review this carefully with my clients. I declare under the penalty of perjury that the information provided in the petition is true and accurate, and you do need to review that with them and have them sign it under signatures of debtors, individual and joint. We're now moving on to the next part of the bankruptcy filing. The Statement of Social Security Number or Individual Taxpayer Identification Number. This is a form which is the only place in the bankruptcy schedules where the entire Social Security number or taxpayer identification number of the debtor is set forth. It gives the name of the debtor, that the debtor has a Social Security number, and the full Social Security number. If the debtor does not have a Social Security number but has an individual tax identification number, it provides that information. And there's also a checkoff box if a debtor does not have either a Social Security number or an individual tax ID number. It is not required to have one of those in order to file an individual in a Chapter 7 proceeding. The next line provides the same information for a joint debtor. It is signed under the pains and penalties of perjury, and it will be reviewed with the debtor at the Section 341 meeting to ensure that the person who files the bankruptcy has the same Social Security number as the person who signed the petition. Moving on, disclosure of compensation for attorneys for the debtor, something that I'm sure will be very important to you. This is the place where you must tell the court and the creditors how much has been charged to represent the debtor, and it is set forth the amount for legal services I have agreed to accept. And it sets forth, prior to the filing of this bankruptcy, prior to the filing of this statement, I have received how much, and how much is still owed, how much is to be paid after the filing. Most importantly, who paid the money? The source of compensation must be disclosed. So if the debtor didn't pay it, if they borrowed it, you must disclose that. There is a certification that is filed with the bankruptcy court. It is not signed by the debtor, it is signed by counsel. And it sets forth that it's under Section 11 U.S.C. 329A and 2016B that you certified that the compensation paid within the year was for in contemplation of the bankruptcy filing. When the debtor signs the bankruptcy petition, as we noted before, there was an Exhibit D that needed to be attached. That is the individual debtor statement of compliance with the credit counseling requirement. And not only does the debtor sign that, certifying that they have taken the credit counseling, they've taken it within the 180 days before the filing, but they also must have provided a copy of the certificate, and the certificate is attached with the Exhibit D when the bankruptcy is filed. There are several other pages that are contained in the bankruptcy petition which we're not going to review today because it's time to move on to the information as to the schedules of assets and liabilities. Schedule A, real property. This is the bankruptcy schedule where the debtor sets forth a description of all real property. They describe the property with the location, the nature of the property ownership, such as tenancy by the entirety, joint tenants, tenants in common, however they own the property. The nature of the debtor's interest in the property, whether it's owned by the husband, the wife, joint, or community. The current value of the property. This value must be listed without taking any deduction for the secured claims. The amount of the secured claim is set forth in the next column. Schedule B. Schedule B is a schedule of personal property, and it is very extensive, and you should spend some considerable time not only going over this information with your client, but making sure that you've checked all the documents which they've given you to support the veracity, because these schedules are signed not only under the pains and penalties of perjury, but you put your signature on them as well. Number 1, how much cash does the debtor have on hand at the date of the filing? It is not good enough to use old information. You need to have that updated really as of the date of the filing. Same with checking, savings, or other amounts deposited into financial accounts. An up-to-date bank statement is always an imperative when a filing is being prepared. Does the debtor have any security deposits with the public utilities, telephone companies, landlords, and others? This information should be set forth here. Number 4, household goods and furnishings, audio, video, and computer equipment. Should they take a full inventory? Yes, they should take a pretty detailed inventory and provide it to you. Depending on the jurisdiction where you practice will depend on how much information you should provide on your schedules. It does vary from jurisdiction to jurisdiction. Same with books, pictures, art objects, wearing apparel, furs, and jewelry. If an individual provides me with information with a 0, then I have to wonder, because you will not find individuals with no clothes. Firearms, sports equipment, photography equipment, hobby equipment, all must be listed. If it's of nominal value, say so, but if it has something of value, that also must be clearly spelled out. Another important part, which is often overlooked by individuals, is whether or not they have interest in life insurance policies, whether there's a cash surrender value of those policies. You should ask for a copy of the policy so that you can check that yourself. Does the debtor have any annuities? This becomes important depending on the jurisdiction and the type of exemptions which they're going to be claiming. Schedule B moves on. There's quite a lot of personal property. Does the debtor have an interest in an educational savings plan, a 529B1? If so, be sure to take a look, because there are limitations on how much can be put into a 529 plan on an annual basis in order to be protected in a bankruptcy. Are there interests in IRAs, ERISA qualified plans, KEOs? Does the debtor hold any stocks or interest in incorporated or unincorporated businesses? Does it hold any interest in partnerships and joint ventures? Now the next one, accounts receivable, may be surprising to those of you representing an individual, But you will find that this personal property schedule is the exact same document which is used for businesses as well as individuals. And so you must go over each line item to be sure that you've covered it all, even if you don't think they're going to be applicable. Alimony, maintenance, support, and property settlements must be set forth. Is the debtor owed any money, including tax refunds? It's very important, particularly between the months of January and April, to check with the debtor to see whether or not they're going to be entitled to a tax refund, because if they don't claim it as exempt, it could be lost to the Chapter 7 trustee. Are there any other equitable or future interests? Life estates. You may remember in the beginning we were talking about estate planning as something which should be considered before filing. And that is because if an inheritance is imminent or has just been received, or somebody has just passed, or whether or not an inheritance is expected within the 180 days of a filing of a bankruptcy petition, you will want to know that and take appropriate steps. Not last or least is whether or not the debtor has any claims. Have they slipped and fallen and have a lawsuit? Do they have any other type of lawsuits pending? Lost wages, loss of job, the medical malpractice. All of these items should be fully explored with the individual before a filing is contemplated. Still more on the personal property. Automobiles, trucks, trailers, and other vehicles, accessories, all must be itemized. A Blue Book value should be obtained for each vehicle, and you should be prepared to submit that documentation to a Chapter 7 trustee in order to support the claimed value set forth in the bankruptcy schedules. Boats, motors, and accessories, same. Office equipment, furnishings, and supplies must be fully set forth. And as I said it before, if the individual is not doing business, many of these will not be applicable, but go through them anyhow to see whether or not the debtor has any machinery, fixtures, or equipment. Sometimes people have small businesses in their backyards and they forget to let you know, or they have equipment in their garage. All of that should be fully set forth so it can either be protected by exemption or disclosed to a Chapter 7 trustee. Inventory, animals, crops, growing or harvested, farming equipment or implements. Some people list their cats and dogs on their schedules. As a practice pointer, I don't do so unless there are significant expenditures which are itemized on the Schedule J of expenses, and so therefore would cause a Chapter 7 trustee or creditor to want information as to who or what the animal was. And finally, there's a catch-all. Other personal property of any kind that's not already listed needs to be itemized. The name of the game in bankruptcy and assisting somebody in obtaining a discharge really has to do with full disclosure, and it is your job as a debt relief agent in order to ensure that they're able to get the discharge that all information is fully and accurately disclosed. It is the most time-consuming part of the investigation in getting ready for a bankruptcy filing. Schedule C in a bankruptcy schedules has to do with exemptions and whether or not your state allows you to claim for your client state exemptions under state law or federal. You will need to look at that on a case-by-case basis depending on where you live. I practice in Massachusetts, so my clients are able to determine an exemption claim based upon either state or federal exemptions. And we look at that based upon what assets we are trying to protect on their behalf. The homestead exemption in Massachusetts is $500,000 and can be even $1 million for individuals who are over 62. Some states have unlimited exemptions, and some states do not have state exemptions at all. The bankruptcy petition provides a checkoff box whether or not the debtor is claiming the exemption under state or federal law. It then requires that you provide a full description of the property and a specification of the law under which you claim the property as exempt, the value of the claimed exemption, and the current value of the asset claimed. If you use bankruptcy software, it will assist you in making those determinations, and I cannot urge you more to use good software because it will make your life so much easier. Let's move on to Schedule D, which is a listing of creditors holding secured claims. What's set forth in Schedule D would be creditors with car or truck loans, boat loans, motorcycle loans, mortgages, executions, real estate attachments, tax liens, and timeshares. This is the place where all creditors are listed who hold collateral for their claims. You must very clearly note the name, the address, the account number of the creditor, the date the claim was incurred, the nature of the lien, the amount of the claim, and the amount of the collateral. Schedule E. This is a schedule for creditors holding unsecured priority claims. There is a checkoff box in the event that the debtor does not have any debts that fall into this category. But let's review those that they do, and then you will need to attach a separate schedule listing each one. Domestic support obligations, such as alimony or child support. Wages that are owed. Wages and salary, which are owed within 180 days. For example, if the debtor is a sole proprietor and has employees and owes employees for salaries. If the debtor has contributions to employee benefit plans that it owes. Not so common in Chapter 7 debtors, but much more common you'll find debtors who owe taxes. Taxes which are owed should be listed in Schedule E. Finally, claims for death or personal injury while intoxicated. If there are creditors holding these types of unsecured priority claims, set forth on a separate schedule the exact information which is set forth in all the others. Name, address, amount, account number if there's one, the date the claim was incurred, the amount of the claim. Schedule F is for creditors holding unsecured non-priority claims. Typically, this will be credit cards, personal loans, medical bills. It could be any type of an unsecured claim. What must be set forth in this schedule is the name, address, amount, and account number. You should have your client order a credit report, or you should order a credit report for your client in order to be sure that you're able to provide the notice to the appropriate holder of the claim, because as we know in many instances, creditors may sell or debts may be acquired by creditors or third parties for servicing, and it's important that notice be given to all creditors of the action that's being filed by the debtor. You should be sure to then, as I said before, you want to be sure to list all known holders, assignees, or transferees of the debts. Schedule F provides checkoff boxes. Is there a co-debtor? If so, who is it? Husband, wife, or joint? It could be a third party. Set forth the date that the claim was incurred and whether or not the amount is contingent, unliquidated, or disputed. If the debt is disputed, be sure and list it as disputed and put down the amount of the claim if you know it, but if not, at least schedule it for $1 or put down the words unknown. The bankruptcy software will provide you with the ability to have as many sheets on Schedule F as you may need in order to complete this information. The next schedule we're going to look at is Schedule G, Executory Contracts and Unexpired Leases. Schedule G outlines things like leased vehicles, rent to own, if you're renting a property, if you are the tenant of a property. This is the information where the name of the landlord must be spelled out together with the mailing address. This becomes particularly important, as you noted before, when we talked about whether or not the debtor was a tenant in residential property, because there are certain requirements for leased property and certain deadlines which must be met in order for the debtor to retain leased property in a Chapter 7. Schedule H provides the ability for a creditor to know who else is responsible for a debt. If the debtor's spouse is a co-obligor, that person's name must be listed. If the debtor has had an obligation co-signed by a friend or a family member, or has co-signed on behalf of a child, a friend, or a family member, this information is disclosed here. There is no co-debtor stay in a Chapter 7 proceeding, but there are co-debtor stays available in a Chapter 13. So if this is a significant issue, your client may want to consider discussing a Chapter 13 proceeding with you instead. We're getting to the end now of schedules, and the last two things which we're going to talk about are income and expenses. Income is Schedule I, and is a very detailed listing and must be very carefully reviewed. In order to do so, you not only want to review the debtor's pay stubs and payment advices which they've given you for the 6 months prior to the filing, but must carefully go over the information contained in the questionnaire. What is the debtor's marital status? How many dependents do they have? If they have dependents, you do want to list them. Because of privacy considerations, you should never put the names of the children. Just put son or daughter and the age. If they care for elderly parents or have other types of dependents, that information also should be set forth in the dependent section. This information is useful not only for completion of the Schedule I, but of course will need to be used in conjunction with the completion of the means test. Employment. Even if the debtor is filing and the spouse is not filing, employment information must be provided for both the debtor and their spouse. What is the occupation? Who was the debtor's employer? How long have they been employed? And what is the address of the employer? And then you have to review with them the income. What are the gross wages or salary? Is there any overtime? Spell that out, particularly if it's regular. What are the payroll deductions? Is there income from a business if they're self-employed? Is there income from property, such as rental property? Is it a 2-family or a 3-family? All that income must be set forth. Is there income received from alimony, maintenance, or support, Social Security, food stamps, or contributions such as from a grandma? Not all this income is taxable in order to be disclosed, but all income from every source does need to be set forth in Schedule I. Schedule J is the expenses. As I indicated before when we were talking about the income, expenses include family expenses, not just expenses of the debtor. So Schedule J will set forth the rent or the mortgage payment, whether or not the real estate taxes or insurance are included in that amount. If they're not included in that amount, they do need to be set forth. What are the maintenance and repair costs for running the property? How much do the utilities cost? Water, sewer, telephone, cable, telephone bills, internet bundle, cell phones. You will want to review all of those bills and make sure that the information and the data is complete and fully set forth. What is the budget for food? What is the home budget for clothing, laundry, dry cleaning? Are there medical or dental expenses that are not insured that need to be paid on a monthly basis? If they're not on a monthly basis, average them out over the course of a year. What are the transportation costs, not including the car payment, but gas, oil, maintenance? Recreation is also a line item. Just because a person is filing in Chapter 7 doesn't mean they're not entitled to some amount of recreation, and there's a line item for recreation, clubs, newspapers, etc. Charity, tithing is permitted. Insurance, homeowners, life insurance, health insurance, auto insurance, all types of insurance costs must be spelled out here. Taxes, particularly if an individual is self-employed, they need to make payments on a quarterly basis on their self-employment tax. That line item goes there. If they're an installment payment, such as automobiles or other, for example, if the IRS is owed money and they're in an installment arrangement with the IRS, put all that information on that line item called installment. Alimony, maintenance, support, expenses should be fully set forth. And if there's a support paid for a dependent who's not living at home and has not already been listed. Then there's a line item for other, such as school supplies, outings, lunches, miscellaneous expenses which might not have been covered. You have the ability to make a separate listing for any additional expenses which this Schedule J does not provide for. But it's important to make sure that all of the debtor's income and expenses are fully set forth. Schedules A through J are intended to provide a listing of all income, all expenses, all assets, and all debts which an individual debtor is claiming for a filing. Once they have been fully and completely reviewed with the client, they do need to be signed because the debtor files these under the pains and penalties of perjury, and it is from this information that a Chapter 7 trustee, the United States trustee, and creditors will be able to determine what the situation is with respect to the individual who has filed the bankruptcy proceeding. While we're out of time for today, I can't not urge you more to take particular time with an individual in order to assist them in preparing the bankruptcy schedules. Not only will it save you time in not having to amend the bankruptcy petition and schedules, which can be done at a time and expense cost to both you and the individual, but it will save the individual embarrassment and you as well from going to a proceeding and not having the information filled out properly and accurately and completely. There's so much more to a Chapter 7 filing than filling out the papers, and a lot of people don't think so. So before you undertake the filing of a petition on behalf of an individual, read through the code, review your local bankruptcy rules, take a few courses so that you get the basics under your belt, and then if you have any questions, find a mentor, because Filing of a Chapter 7 proceeding is a life-changing event for an individual, and we would not want somebody to go into a proceeding not well handled, not well represented. So thank you very much for your time, and I look forward to hearing from you again.